Good morning to everyone, or I should say good afternoon to everyone at today's public hearing of the Prosecutor Vetting Commission. My name is Christopher Lehman, Chairperson of the Commission, and I declare this session to be open. The Prosecutor Vetting Commission is established under Law 252 on the external evaluation of judges and prosecutors. Law number 252 establishes that this commission will undertake an ethical and financial evaluation of prosecutors who are identified in Article 3, Paragraph 1 of that law as subjects of the evaluation. The commission is constituted to conduct the evaluation pursuant to Article 15 of Law number 252. The hearing is being conducted pursuant to the provisions of Article 16 of that law, as well as the commission's rules of procedure for evaluations under Law 252. The subject of today's hearing is Victor Cazacu, a prosecutor in the Anti-Corruption Prosecutor's Office. Mr. Cazacu, welcome. I'm joined by my colleagues on the commission. First, let me introduce those who are here in person. Starting from my far left is Jan Grauer. To my immediate left, Bernard Levine. To my immediate right is the vice chair of the commission, Virginia Marraro, and to my far right is Herman von Hebel. Joining us by video conference today by a hybrid setup are members Cornel Lebedinsky, Irmantis Mikolonis, and Laura Stefan. I'll note for the record that Commissioner Nadezhda Hryptievsky was recused by the Commission from participating in this evaluation of the subject by a decision of the 1st of December 2025. The subject was previously advised in writing of that recusal. I'll note that the panel is also assisted by members of our Secretariat. This hearing will be conducted with interpretation into both Romanian and English, and to allow for accurate interpretation, I will ask everyone to speak slowly and clearly. These proceedings are being recorded. The recordings of the public hearing will be available online on the Commission's website within 3 days after the hearing. Let me begin by reviewing the procedural status of this case. A report in this case was approved within the appropriate time period allowed under Article 17, Paragraph 2 of Law 252 by a majority vote of the participating members of the Commission on the 16th of January, 2026. Commissioner Lebedinsky's and Commissioner Mikolonis provided dissenting opinions to that report. The full report was sent to the subject and to the Superior Council of Prosecutors in a timely fashion, consistent with the provisions of Article 17, Paragraph 5 and Paragraph 6 of Law number 252. The report of the Commission was rejected by the Superior Council of Prosecutors by a decision of 12 February 2026 under Article 18, Paragraph 3, Letter B of Law number 252, and was returned by the SCP to this Commission for a resumed evaluation. The Commission is now conducting that resumed evaluation of the subject under the provisions of Article 20, Paragraph 2 of Law number 252, and Article 30 of the Commission's Rules of Procedure. This hearing was scheduled pursuant to Article 30, Paragraph 2 of those rules, and is held under provisions of Article 16 of Law 252. The subject was notified of this hearing on the 4th of June, 2026. In the notice of this hearing, the subject was advised that the Commission maintained doubts about the subject's financial integrity. Those doubts were identified and detailed in the annex to that hearing. The subject was further advised that the Commission did not consider it necessary at this stage to hold a further hearing, but would do so at the subject's request. The subject thereafter did request that a hearing be held. Mr. Cazacu, thank you again for appearing at the hearing today. Let me begin by polling the members of the Commission to see if any of the members have additional questions for this subject at this time. That being the case, Mr. Cazacu, I will give you the floor for any statement that you wish to make.
Thank you, esteemed chairperson and esteemed members of the Prosecutor Vetting Commission. I have looked thoroughly through the issues raised in the notice, and I paid attention to the analytical structure of the calculations that are the basis for those issues, though the Commission has established in the notice that it doesn't believe it is necessary to have another hearing of myself. I decided purposefully to come in front of you, to appear in front of you, and to exercise my legal right to be thus present here, to appear in front of you for the third time. I've asked to participate, to appear in this public hearing beyond the strictly procedural matter, because I am certain that only through direct interaction based on numbers and concrete facts, in that way only can we have full certainty with regards to, or we can have clarity with regards to the assessment of myself. I believe that my presence is important because it allows to overcome and go beyond the indicators, the general indicators, and go beyond strictly chronological interpretations. And it allows me to address the logic behind the transactions that are the matter of discussion. Now, as for my request, it is not merely about a mere formal rejection, negation of the findings in the notice. I intend to prove step by step why those general statistics and the way they were used have led to an artificial financial deficit, in my opinion, and has led to a discrepancy that did not actually exist in reality and that is not compatible with the financial journey of my family. With the permission of the Commission, I will read out the arguments that I believe to be pertinent with regards to those big issues, those two big issues that notice was based upon. Thinking about the particular issues in the notice, my first disagreement has to do with the alleged negative balance of 7,256 lei for 2015. I must mention that this deficit represents only 8.35% of the total average consumer expenditure, the CCP, in fact, established at 86,814 lei. This balance does not reflect a real financial discrepancy. It is rather the product of the rigid application of general statistical indicators which are detached from the reality of my family in those years. In 2015, the net salary income of my household was only 77,036 lei, an objectively mathematical amount lower than the statistical CEP by about 9,778 lei. For logical rationale, the actual expenses were limited to the ceiling of the collected income. This structural inconsistency, I believe, is generated by two elements that require particular analysis, individualized analysis, the specific nature of expenses related to a 2-year-old child. Again, if we do this automatic reference to the general NBS indicators for my daughter, who was actually 2 in 2015, does not faithfully reflect reality. A child at that age does not accumulate consumption volumes similar to those of an adult for categories such as transport, 5%, communications, 4.6%, hotels and restaurants, 2.9%, recreation, 2%, alcohol and tobacco, 1.3%, or education. A natural adjustment of these percentages, which are unsuitable for that age, estimated at 5,883 lei, allows for a recalculation of the disputed balance to a residual difference of only 1,373 lei. This remaining amount is fully absorbed by excluding other statistical indicators that did not characterize the reality of our family during that period, of my household during that period, such as the general education share of 0.7% per person. What is also important is the correlation of expenses for healthcare services. Told that all the household members had compulsory health insurance, and our contributions were withheld directly at the source from the gross salary. In the absence of private treatments, and were applicable direct expenses for medicines, vitamins, medical devices, dental services, consultations in private clinics or paid medical services in public hospitals, the automatic application of the statistical percentage in full leads to a burden of a burden of proof of negative fact, which is impossible to fulfill. In conclusion, I believe that this minor balance does not indicate a deficiency in terms of financial integrity, but rather highlights the natural methodological limits of using general statistical indicators to the detriment of a personalized analysis of a case. Now, moving on to the section regarding the 753,332 negative balance calculated for the period from January 1st, 2019 to October 18th, 2019, I must highlight the following, that this balance comes from a methodological asymmetry. The current calculations have isolated in absolute terms the moment of purchase of the new asset, while ignoring the fact that the sale of the apartment on Alba Iulia Street for the amount of 48,700 euros was completed only approximately 20 days later. This artificial segmentation of such a short interval generated the presumption, the allegation of a lack of liquidity, which at the end of the 2019 fiscal year did not exist. Moreover, on the date of purchase of the new apartment, having analyzed the incoming financial flows, there was an amount that was emitted, the one taken as a loan from the parents. Its role was specifically to make sure there was the required liquidity and to work as a financial bridge between the moment of purchase of the new immovable property and the moment of the sale of the previous asset. Subsequently, in establishing the outgoing flows, a duality of approach can be observed. The amount actually paid and legally proven was replaced with a value of about 835,000 lei, the approximate equivalent of 44,000 euros. This theoretical increase in the purchase price, in the absence of certain evidentiary support, formed the premise for generating the alleged deficit. In this regard, the appeal to general orientation benchmarks extracted from public sources, such as real estate data from LARA or the evaluations of the Global Property Guide platform, I believe these represent a useful approach in a particular way when it comes from to the macroeconomic perspective, but it has certain limited applicability at individual level. Although these tools reflect the broad general trends of the real estate market, they cannot address the concrete or contextual elements specific to the asset in question. And therefore, in order to consolidate the credibility of the amount of 835,321 lei, the use of these macroeconomic indicators to the detriment of concrete data, characterizing the factual reality of the years 2014-2019, this restricts the level of precision required for personalized analysis. It must also be mentioned that it was a methodological flow in aggregating these data. For example, the Global Property Guide platform operates with a statistical amalgam, since it does not structurally differentiate and does not present distinct data for the old housing stock of Soviet type built in the years 1970s, 1980s, such as the immovable property in question, as compared to the new housing stock of modern residential type, placing in the same analytical category two types of immovable property with indicators of physical wear, energy performance, and technical infrastructure that are diametrically opposed, is, I believe, a methodological error. Therefore, these general indices, indicators, cannot be established as a mandatory evaluation benchmark for a specific particular immovable property and are not such as to annul the contractual freedom or the presumption of legality of a transaction concluded below the average. All the more so since it completely ignores the structural value gap between the two housing stocks, thereby distorting severely any real comparability analysis. Out of the analysis of the applied methodology, you can see an asymmetrical hierarchy of evidentiary material. There is a tendency to grant predominant legal value to entries of an indirect or to some records of indirect or administrative nature to the detriment of direct contractual or testimonial evidence administered during the procedure. Though in the case there is incontestable direct evidence, such as the authentic sale and purchase agreement, the confirmation expressed by the former owner, the declaration, the focus was on a document taken, on a number taken from an internal internal document of a bank dated 2014, detailed at items 18, 20, and 30 in the hearing notice. More precisely, the purchase value for the year 2019 was estimated at 835,321 lei by taking over a position from an internal guarantee assessment form issued by a commercial bank 5 years earlier in 2014. And this entry, this record, this information is in file number 165, page 54. The Commission itself has noted in item 19 that it was not able to obtain the original valuation report and that it didn't know what the methodology was, the one that the bank applied, that is. Nevertheless, in item 20, it draws the conclusion that that form provides a more reliable indication, though the mortgage value recorded in that same document of 668,200 lei was much more relevant, being assumed by the parties through the will and agreement of the signatory parties. From a technical perspective, no reasoning was provided as to why an average value estimated by the bank should prevail over the value of the mortgage actually agreed upon. This hypothesis, the way to address this matter is also visible at item 30, where an alternative calculation is introduced, advancing the possibility that the value of the asset may have reached the threshold of 1,229,670 lei. This is regarded as a distinct possibility. The scenario is retained as a distinct possibility, although there is no indication that an asset located on the secondary real estate market in 2019 would have confirmed such a historical value. To support this increased reference value, in item 21, focus is put on a restrictive view of the physical condition of the asset, maintaining that the subsequent investment of 200,000 lei represented only a cosmetic, so to speak, intervention based on preference, which would not economically justify a reduced purchase price. In relation to this approach, I must state that my detailed explanations, the ones that I provided during the public hearings, were not fully used. I rigorously set out the considerable volume of structural rehabilitation and interior fitting out works required by the condition of an apartment from an old housing stock, which in this way justifies the reduced purchase price. I reiterate what was also submitted during the written answers and at the hearing of the 7th of November 2025 regarding the amount of works carried out, namely approximately 40,000 lei was spent for the exterior windows and the balcony and about 30,000 lei for the interior doors. There were works involving some materials for the sanitary unit, the bathtub, the terracotta tiles, the taps, approximately 50,000 lei. For finishing works, about 10,000 lei. Repairs to the engineering network, steps, water pipes, about 10,000 lei. Painting works on the interior walls, including materials, about 10,000 lei. Electrical works, 10,000 lei. And furniture and household appliances, plus various other expenses of about 40,000 lei. In fact, the complex and indispensable nature and the complex nature of these repairs, this was assessed during the public hearing of November the 7th, 2025. There were many questions that were asked by the members of the panel B. Having analyzed the volume of the amount of works detailed, considering also the degree of the works, well, they were stated as being not the simplest and requiring time. They were defined as major works, strictly necessary so that it would be suitable for the owner to live or stay in that apartment. This is taken from the official hearing recording starting with the time-coded 1.45 minutes. For any real estate asset located in an old apartment block, such a body or such an amount of works is not a simple aesthetic or cosmetic retouching, so to speak, but a capital and actually comprehensive renovation of the entire dwelling. In conclusion, regarding this item 21, in my opinion, there is an obvious analytical contradiction taking place. If these works had been simple aesthetic interventions with the funds that was indicated, this would implicitly confirm that the structure and initial condition of the apartment was degraded and unrenovated, which justifies from an economic standpoint the smaller purchase price. If the asset had been in an impeccable technical condition corresponding to the theoretical value of more than 835,000 or even 1,229,000, then no immediate structural intervention would have been necessary. More than that, admitting the assumption that the real purchase value was 835,000 or even 1,229,000 lei, as set out in item 30, to which the investment of 200,000 lei would be added, this would place this apartment within the limits of a total cost that the value of which exceeds even the presumed prices at the maximum ceiling applied to the old housing stock for an apartment from the secondary housing market in whatever condition that may have been, and would place such an acquisition in an area of total economic illogicality. The final result would have allowed any rational buyer to purchase an apartment in a new building at a much larger surface area and with infrastructure conditions clearly superior to the one acquired by me. I would also like to address the matter of the financial capacity of my parents to grant the loan of 23,000 euros in October 2019, an aspect that is addressed in items 31-48 of the notice. From the outset, I believe it is essential to make a clear distinction in legal terms and in economic terms between the terms of donation, which implies a final transfer of ownership and an irreversible decrease in assets, and that of a short-term loan, which worked exclusively as a mechanism to ensure temporary liquidities. I would like to emphasize that this amount did not generate an increase in the net wealth of my family in 2019, and correlatively, it did not represent a decrease in my parents' wealth and my parents' assets. It was a simple bridging operation intended to cover a chronological gap of only 20 days, as far as my situation is concerned, between the purchase of the new property and the collection of the price for the old one sold. At the end of the tax year 2019, the financial balance naturally rebalanced itself. The new apartment was financed essentially from the proceeds obtained out of the sale of the old property, and the loan was given back to the source. The source of my parents' financial availability. The source of my parents' financial availability was explained transparently through the savings accumulated from my father's work in Germany, the successive capitalization of import vehicles, and my mother's official income. My father engaged in construction works and repairs in Frankfurt, beginning in 1996. The frequency of his trips was 2 or 3 times a year, the duration being 2-3 months. The amounts he'd collect were about 2,000, 3,000 euros a month, depending on the specifics of the works, and upon entering the country, they did not exceed the legal threshold required in customs declaration. Thus, for the period 2012 through 2019, the estimated annual income for savings stood between 8,000 euros and 10,000 euros, allowing the accumulation of savings in cash, which back in 2019 exceeded the amount of 45,000 euros. To provide the Commission the real possibility to verify this fact, I made available a list of contact data of 11 people alongside with whom my father worked. 4 of them were directly contacted by the Commission, and 2 others subsequently sent explanations. All these data converge toward the confirmation that my father has genuinely worked in Germany and that he had an actual income source. In items 39 and 42 of the notice, it is noted that there are some issues with those testimonies being considered purely declarative or lacking an oath. Nevertheless, in the spirit of fairness, one must bear in mind that the requests for evidence such as signed contracts, official payment receipts, or international bank transfers for the activity defined from the outset as conducted by a non-resident and informal, that constitutes an impossible evidentiary burden to meet for strictly objective reasons. To add to the financial picture, it is relevant to look into the history of my father's secondary activity. He imported in total 19 vehicles, and this was funded from the income earned in Germany. This information directly corroborates his periodic presence on German territory. The purchase and import of vehicles has represented a rational method to optimize transportation costs upon return to Moldova, combined with a strategy of conservation and multiplication of savings through the subsequent resale of those goods on the domestic market of Moldova. The money obtained out of the successive sale of these vehicles registered, for example, at the end of the years 2011, 2012, 2013, 2014, 2015, was kept under the form of savings in cash. Each new import was financed from the current income obtained from work, allowing thus the gradual accumulation of capital from previous sales. In this context, when analyzing the correlation between the theoretical projection, table number 3, item 47 of the notice regarding the saving potential of my parents' household, and the factual data presented in the fourth round, question 2, which is what the data on the table is based, we can see a series of methodological asymmetries, which, once clarified, completely redefine the conclusions regarding the financial availability of my parents. Essentially, there are 3 structural elements involved. The first one is the principle of rotating of assets versus final consumption. The algorithm in table number 3 tends to treat each car purchase as a pure consumption expenditure with no initial source definitively deducted out of the family budget. In reality, the factual data show a rollover in capital preservation model. The sums of money obtained out of the successive sale of vehicles generated a flow of financial resources. This capital was not leaving the family asset circuit, but re-entered in the form of cash into the household reserve fund, ensuring a permanent base of liquidities. The second element has to do with the confirmation of capacity through honored tax and customs obligations. The allegation regarding the potential for saving is substantially undermined by the official data made available by the Customs Service. The records show that my father has paid directly to the state budget taxes, excise duties, and customs duties related to the import procedures for 19 vehicles. In this regard, a relevant correlation is taking shape in the current analysis. In that same table number 3 for the year 2012, for instance. In 2012, there is a negative balance, alleged minus 10,458 euros. But the data show that in the immediately following years, 2013, 2014, and 2015, the household budget had certain and available liquidity flows necessary to fully support those payments for the successive imports that followed for the car that entered the country. From an economic perspective, the constant capacity to generate and run such a volume of tax duties represents an objective indicator of financial strength, fully compatible with the accumulation of reserves later used for granting the loan in autumn 2019. The third aspect, delimitation of the financing circuits within the household and the role of external work. The answers submitted in the fourth round, second question, have clarified an obvious functional dimension. The current subsistence expenses on the territory of the Republic of Moldova were covered from the regular salary income of my mother as additional contribution to my father's earnings. This fact allowed for the amounts resulting from the car transactions and from his work in Germany to remain largely intact in the form of cash reserves. Failure to separate these distinct financial flows explains the appearance of that theoretical restrictive balance in October 2019. Therefore, I believe that the inconsistencies identified in table number 3 do not reflect the real absence of funds, but are the consequence of applying a rigid analytical model which omitted the specific economic circumstances of my parents' household work. I would also like to respectfully express my disagreement with the deductions in items 44 and 45 with those conclusions, according to which using an import agent would suggest my father's absence from Germany. In the same line of reasoning, the absence of green card insurance policies issued in the Republic of Moldova for the personal cars cannot constitute a valid argument against his presence in Germany. A non-resident worker does not need to travel by their own car registered in the Republic of Moldova in order to work abroad and to stay there. There is international transportation, regular passenger routes, for instance. On the contrary, the official data of the border police for 2019 through 2023 confirm my father's predominant presence abroad without crossing the border by personal car, which validates the systemic and historical nature of his travel over 2012 through 2019. Finally, indisputable material evidence of my parents' financial capacity is represented by a certain fact that on the 20th of February 2020, shortly after I repaid the loan, part of their cash savings amounting to about 12,000 euros was deposited in an account opened with a commercial bank. These deposits are still active at present, and the official data are already in the possession of the Commission. The creation of these active bank deposits demonstrates the existence of a consistent financial surplus in my parents' budget. This banking reality further highlights the signs of deep methodological asymmetry and the calculation algorithm applied in table number 3. It is economically impossible for a household for which a negative balance of 8,032 was presumed on paper on October 2019 to later have, in a concrete and verifiable way, only a few months later, in February 2020, to have a net availability that is of a different value. My father was back in December 2019. So that is with regards to the 12,000 euros issue regarding the creation of long-term bank deposits. Now, in my final conclusions, I would like to draw attention to the fact that, having performed a retrospective analysis of this case, it becomes clear that the methodological difficulty identified throughout the notice derives from a strictly chronological approach to the consecutiveness of real estate transactions in autumn 2019. This hypothesis regarding lack of funds is based exclusively on the time gap between the moment of acquisition, procurement of the apartment in Ciocana district and the subsequent sale shortly thereafter of the apartment in Boiocani. From an economic and financial audit perspective, it is essential to clarify that this temporary cash flow asymmetry, analytically assessed as a deficit, as a transitory deficit, did not influence and did not increase the value of my household's net assets. The factual context does not reveal an unjustified accumulation of capital or a net increase in assets, but describes a standard patrimonial asset reconfiguration operation whereby one asset was replaced with another asset of equivalent value with transitory financing through a bridge, meaning the loan mechanism. Consequently, reinstating the real contractual price into the analytical table, eliminating the double count of expenses, and recognizing my parents' clear economic and financial profile, thinking of the cars issue and the further bank deposits, the records with the customer service, they rigorously demonstrate that the asset balance remained consistently positive. And this is all with regards to the issues raised in the hearing notice. And in closing, I would like to underscore that my entire professional career, in my personal behavior and conduct, I follow the principles of legality and absolute transparency. The materials, the information in the evaluation file prove this. I understand fully the rationale, the mathematical rationale, the indicators, the statistical indicators used by the Commission. However, the actual dynamics of a household in their day-to-day life, it cannot always be regarded through the lens of standardized behavior. I think that the evidence in the evaluation file and the explanations, and my explanations, the explanations I provided during the hearings so far and today prove beyond any reasonable doubt that every transaction, every Moldovan leu in the financial journey of my family has a certain origin that is legal and perfectly justified. I trust that the financial analysis that will finally be made by the Commission, I think that analysis will reflect objectively the facts, and that the decision will be based on legal certainty, such as to go beyond the abstract indicators and beyond interpretations that are strictly chronological. Thank you for your attention and for your time.
Thank you, Mr. Cazacu. Let me just again poll the other members if anyone does have any questions or interventions. Seeing that they do not, Mr. Cazacu, let me just offer you again the floor in case you would like to make any concluding final statement for the Commission.
Thank you, Chairperson, but I anticipated that and I said my closing words without being asked for.
Accordingly, let me thank you for your participation in this hearing today and throughout the evaluation process. The Commission will now deliberate on the matter, and this hearing is closed.
Thank you.